各位，咁我哋夠法定人數。
All right, members, we've got a quorum already. This is the meeting of the Bills Committee on the Interception of Communications and Surveillance Amendment Bill 2015. Please invite the administration in. At this meeting, we're going to have a discussion with the administration on the bill. This is the first meeting for discussion of the content of the bill with the administration. So I will invite the officials to take us through the bill, and then I will invite questions and comments from members. And then we can have in-depth discussion on certain issues. And then finally, we will start clause-by-clause scrutiny. We will conduct a public hearing to hear the public's views at a later stage. So with us today, we have Mrs. Millie Ng, Acting Deputy Secretary for Security, Ms. Alice Yeung, Assistant Secretary for Security, Mr. Godfrey Khan, Senior Assistant Solicitor General, Department of Justice, and Ms. Monica Law, Senior Assistant Law Draftsman, Department of Justice. Welcome. So, Mrs. Ng, can you give us a brief introduction on the bill? Thank you, Chairman. Thank you, members. This is the second meeting of the Bills Committee. And this is the first time that we can have a discussion on the content of the bill. So let me say something about the background. Concerning interception of communications and surveillance, such operations are critical to the capability of our law enforcement agencies in combating serious crime and protecting public security. The ordinance was enacted in August 2006. The ordinance provides a statutory regime to regulate the conduct of interception of communications and covert surveillance by LEAs. So the purpose is to strike a balance between the need to combat serious crime and the need to protect privacy rights. Before LEAs can carry out interception and surveillance operations, they must, according to the ordinance, obtain authorization from the panel judge. And an application can be made only when the LEA needs to combat serious crime and protect public security. And there must be the test of proportionality, which must be satisfied. Under the ordinance, there is a commissioner, an independent commissioner, who ensures compliance of the ordinance by LEAs. And the panel judge must be a CFI judge. And the commissioner must be an incumbent or former High Court judge or a former CFA, a permanent judge. The ordinance was passed quite some years ago, and over 2,800 people were arrested in the wake of the surveillance and interception operations. So you can see the importance of the ordinance to the protection of law and order. The former commissioner, Mr. Justice Wu, made a few recommendations to enhance the effectiveness of the ordinance. The Code of Practice was amended in the light of his recommendations. Those were recommendations which didn't require legislative amendments. And then there are some recommendations which require legislative amendments. And the purpose of this bill is to implement a recommendation by the former commissioner, and that is to require the production of interception products and surveillance products, collectively known as protected products, obtained under the ICSO for the Commissioner's inspection. And we also seek to implement a number of technical proposals recommended by the former commissioner to enhance the effectiveness of the regulatory regime under the ICSO and the clarity of certain provisions in the ordinance. All the proposals in this bill have been endorsed by the incumbent commissioner. As I have said just now, the main purpose of the bill is to require the production of protected products obtained under the ordinance for the commissioner's inspection. So the commissioner and his officers will be authorized to inspect protected products. And these include special cases, for example, irregularities, or non-compliance cases, or cases involving journalistic materials and LPP. And the commissioner will also be allowed to carry out random checks of the various cases. So in order that a commissioner can discharge his statutory functions, he can require LEAs to provide any protected products, including any protected products that contain information that is or may be subject to LPP in his or her possession to the commissioner. We also propose to provide for an express power for the commissioner to delegate his power to examine protected products to an officer working in his or her office who is responsible to him or her. And for protected products which have been inspected by the commissioner and which are no longer necessary, they should be destroyed as soon as the retention is no longer necessary. And now I would like to give members the rationale. Under Section 53(1)(a), the Commissioner can, for the discharge of his functions, require any public officer or any other person to provide any protected to provide any document to the Commissioner. But then the ordinance doesn't provide for an express power for the Commissioner to inspect the protected products. And Section 59 provides for the keeping and destruction of protected products. But then this section is not subject to 53(1). According to Section 59, LEAs have to make the necessary arrangements to minimize the disclosure of protected products. And once the retention of protected products is no longer necessary, the protected products should be destroyed as soon as practicable. And if protected products contain LPP or are subject to LPP, and the materials were obtained by prescribed authorization, then the products should be destroyed as soon as reasonably practicable. So concerning our proposal, including giving the Commissioner an express power to inspect the protected products, there is a need to strike a balance between privacy and LPP and the need for the Commissioner to exercise his statutory powers and functions. We've consulted the Commissioner, panel judges, journalist associations, legal professional bodies, and the Privacy Commissioner. And we have now come up with these proposals in the bill. These organizations, in general, support the giving of an express power to the Commissioner and enhanced protection of protected products. But, of course, there will be privacy implications, and so preventive measures are required to make sure that such intrusion on privacy will be minimized. The Commissioner is of the view that the power to inspect protected products is very important. If this bill is passed, then the Commissioner will adopt suitable supervision and security measures to avoid unauthorized disclosure and inspection of the protected products.
The bill also put forth some technical proposals to implement the recommendations by the former Commissioner in order to enhance the operation of the mechanism, including the how the time gap between the revocation of a prescribed authorization by the relevant authority and the actual discontinuance of the operation by the LEA. And as the former Commissioner said, this is something that has to be dealt with. We also have to deal with the partial revocation of prescribed authorizations and also additional grounds for revoking prescribed authorizations and revocation of device retrieval warrants. And also, there are certain amendments to clarify the special circumstances. So I'll be leaving these to the administration or my colleagues to give you more details when we come to that. At the security panel of this council, on various occasions, we also talk about a comprehensive review. In fact, in July 2013, we briefed the panel on the proposed amendments that we are making now and also the scope of the amendments. At the time, panel members generally supported the amendments. They also indicated that they'd like the administration to table the amendment bill before this council as soon as possible so that the Commissioner will be able to conduct inspections of the protected products. And that's what the incumbent Commissioner said in December at the Commissioner's press conference. He also indicated that he'd like to see the passage of this bill as soon as possible so that he would be given the express powers. So I hope that this bill can be approved as soon as possible in order to enhance the Commissioner's ability to check compliance by the LEAs. So that's all for my presentation, and I'll be happy to take members' questions. Thank you, Deputy Secretary. Just now, the Deputy Secretary already went through the main proposals of the bill, and some technical issues were also mentioned. So I'll now open the floor to members because we have already got the electrical brief. And there are different parts to the proposal. So in order to have a more systematic discussion of the whole bill, may I propose that we follow the different parts of the electrical brief and then we discuss the issues involved. So that would be more effective and more in-depth. So that's point number one. And second, I'd also like to seek members' views on this because prior to this, we also had some general discussion about this ordinance. So with regard to the Interception of Communications and Surveillance Ordinance, we can also have a general discussion of how the mechanism works. So it is not confined to the amendment bill. So whatever your concerns are, you may raise them, and that's for the administration's consideration. If members have any questions, please raise your hands. So I have Mr. Chen Kamlam, 7 minutes for you. Thank you, Chairman. Chairman, I'd like to know this. With regard to the prescribed authorization and also the monitoring of the mechanism, of course, I support that the LEAs should have the power to protect public safety and the ability to combat serious crimes by conducting interception of communications and covert surveillance operations. But then we also need to strike a balance in order to have checks and balance against the powers enjoyed by the LEAs, and that's why we have authorized the Commissioner to monitor the operation of the LEAs. So I'd like to know, over the past few years, with regard to the Commissioner's requests for the LEAs for materials under such operations, has he ever encountered any difficulties, or would there be such situation arising, that is, where such materials have been forwarded to the Commissioner or his subordinates? Would that result in the disclosure of the subject who is being intercepted or who is the subject of such surveillance operations, which might affect the enforcement operations? Deputy Secretary. Thank you, Chairman. Thank you, Mr. Chen, for your questions. On the first question, the Commissioner or the former Commissioner, have they encountered any difficulties? If you've noticed the annual reports submitted or presented by the Commissioner in the past, both Commissioners have reflected that they've got some problems. With regard to the ordinance, the Commissioner is of the view that if the Commissioner is able to have access to such protected products, then that would serve as a deterrent effect for the LEAs who might have deliberately breached the requirements where there are LPP materials or journalistic materials, or in the declaration by the law enforcement agency. Well, if the substance might not have been the same, then if the Commissioner is able to have access to such materials, then that would enable him to have a better or more effective monitoring. But then the mere fact that with this power given to the Commissioner, that would already serve as a very effective deterrent effect. But then under the existing ordinance, the Commissioner does not have access to such products. And as Mr. Chen said, well, such materials or products would involve very sensitive personal data or privacy materials. It might also have contained materials that the LEAs might not have intended to obtain, and therefore the Commissioner thinks that this is not good enough. That's why he proposes that there should be amendments in order to enable him to have access to such materials. And if you've read the reports by the Commissioner or the former Commissioner before, whenever there are protected materials or products involving LPP materials or journalistic materials, the LEA is required to retain all the materials for the inspection by the Commissioner, so that if the Commissioner is given that power, then he might inspect such materials in order to check if the LEA's application has been fulfilled or complied with. And Mr. Chen also made a very important point. Well, at present, while the Commissioner has yet to exercise such power, but then when he and his team conduct inspection in their day-to-day work, they would have access to highly sensitive and confidential information, and they've adopted very stringent measures to protect such materials. So with regard to such inspection arrangements, the Commissioner has also indicated to us that he would come up with appropriate security measures and control measures to ensure that any unauthorized access or risk of disclosure would be kept to the minimum. So he has also proposed some specific measures. The former Commissioner has publicly said that in implementing this proposal, the protected products would be kept in the LEA's premises. In other words, such products would not have to be transported to his office for inspection. So he will personally go to the LEA's premises to inspect such products. So that would already reduce the risk of such products being compromised in the course of transmission or transport. And he would also monitor the subordinates, and he would come up with very stringent guidelines for the officers to carry out such inspection. And there would also be very stringent security check. And for officers who have violated the rules, even if they work in the office of the Commissioner, so like other LEA officers, if they have breached the rules, they would also be disciplined. So for colleagues working in the Commissioner's office, they are all civil servants, so they would also be subject to disciplinary actions if they breach the rules. Mr. Chen? So did the former Commissioner make the recommendations while he was in office, or did he make the recommendations after he has stepped down? Well, while the former Commissioner was still in office, well, for all the recommendations that we are proposing today, well, all of them have been proposed or recommended by the former Commissioner in his annual reports. Concerning this inspection arrangement, he didn't spell out the entire recommendation in one report. In fact, well, the earliest report was made in 2009 on the operation in 2008, and he already made that suggestion. And then in 2011, when he released the report on 2010, he further said that this would also cover the products of covert surveillance. So he made the recommendations while he was still in office. Mr. Chen, I'd also like to understand this. Well, after the products have been passed on to the Commissioner, have there been any occasions on which such materials have been leaked? Well, my understanding is that there wasn't. Thank you. Next, Mr. Christopher Chung, and then Emily Lau. Thank you, Chairman. If that is the case, then the Commissioner will have very extensive powers. So what can restrict the Commissioner in exercising his powers? So are there any provisions which would restrict or contain the Commissioner in exercising his powers? That's point number one. And number two, and would he be able to conduct such inspections under specified circumstances? For example, an LEA officer might be investigating a case, and he might have obtained the materials in the course of his investigation. But then for the Commissioner, he can have access to all cases. So whenever he likes it, he will be able to do so. So you have to make sure that you have reasonable grounds to suspect, and therefore you can inspect. So then it must be conditional. And also, if he inspects certain materials, there should be restrictions on what he can inspect. He should not be allowed to have access to all materials. For example, if he has any suspicion that the LEA might have obtained more products or materials than necessary, then he would have to conduct inspection in order to ensure that such powers would not be abused by the Commissioner. And there is another danger. Certainly, he can also authorize certain officers to inspect the materials. And you said that he would come up with guidelines and so on. But then these are not laws. These are just internal guidelines. And when they are just internal guidelines, would there be loopholes? Would there be abuse by his officers? So in drafting this bill, how can we prevent this from happening? So can you answer the questions? Yes. Deputy Secretary. Thank you, Chairman. Thank you, Mr. Chung, for your questions. Under the mechanism, the monitoring authority is the Commissioner, and in fact, as the regulator, he has to have sufficient powers in discharging his functions. So it's not that anybody can become the Commissioner, because in designing the ordinance, the mechanism is such that, well, whether it's authorization or the person who is to monitor this, this is a very sensitive job. That's why we have to ensure that both the Commissioner and his team would have to be neutral parties. That's why in appointing the Commissioner, the requirement is very high. Under the law, the Commissioner has to be an incumbent or retired appeal court judge or CFI judge. I don't quite agree, because you're actually advocating the rule by man. In fact, if we have trust or faith in the rule of law, you will have to make sure that there would be checks and balances, or else whoever is in that post, well, in exercising his powers, he would also be subject to certain restrictions. We should not just think that whoever is appointed will have this halo effect, and therefore he can do whatever he wants. Well, that's fair. That's why we have said that, well, you will have to tell us what are the checks and balances.
Chairman, I think what is important is how the Commissioner exercises his powers and functions. Now, under the ordinance, under the present ordinance, the Commissioner can require that the products be examined by him because he needs to discharge his duties. And there are records concerning what materials he has inspected. And also under the mechanism, the Commissioner is appointed by the CE. So the former Commissioner has said that setting a threshold will hinder the Commissioner's exercising of his powers. In fact, we did provide a paper to the security panel. There are no restrictions, Chairman. I think she's telling us that there are no restrictions. I think at least he needs to a report to another person, say the CE, if he inspects the protected products. So you simply believe that he is someone great. He will exercise self-discipline. He will produce a report at the end of the year. Now, I think at least this Commissioner, say, needs to submit a report to the CE 1 month or 2 months after he has inspected the protected products. Now, say, for example, the CE, after reading his reports, may decide that this Commissioner has inspected a lot of protected products unnecessarily, and so the CE will then decide whether this Commissioner should be reappointed. But now it seems that you're just asking us to have trust in the Commissioner. He is a great person and he will exercise self-discipline. Now, in fact, both the former Commissioner and the incumbent Commissioner do give very detailed accounts on how he discharges his duties, how he obtains reports from the panel judges. So all such information is available in the Commissioner's annual report. The annual report is submitted to the CE and it's also tabled in LegCo. And in fact, every year the Commissioner holds a press conference or press briefing to explain his work to the public. I think every time he inspects some protected products, he has to explain why he has decided to do so, what his findings are. Now, say for example, he inspected protected products on 10 occasions, and on all those occasions he did not find any irregularity, and that would really reflect on his judgment. Now, Mr. Chong, I want to say that in fact there was a very detailed discussion before the enactment of the legislation concerning who the commissioner should be. We said that he must be an incumbent or a former High Court judge. After all, this is a supervisory body. This is not an enforcement body. So is it that we need to have another supervisory body supervising the commissioner or the commissioner's office? I want to say that in fact your concern was dealt with in great detail when the original bill was discussed in this council. Ms. Emily Lau and then Mr. Tony Chair. Thank you. As the Deputy Secretary has pointed out, many of the recommendations and amendments are worthy of our support. In fact, we've met the former commissioner and the incumbent commissioner. Chairman, is it that we're going to have a public hearing, and when will that be held? 2nd of May. 2nd of May. But is it that we're going to meet the commissioner? Now, yes. I intend to extend an invitation to the commissioner to come to our meeting. But I want to say that previously we sent invitations to the commissioner, inviting him to come to discuss his annual report with us, but all the invitations were turned down. Now, the incumbent commissioner may not want to come, but can we invite the former commissioner? And will we be meeting him on the 2nd of May if he decides that he will come, or I think on another date? Now, because many of the recommendations were put forward by the former commissioner, and we really would like to meet him, so let's try to fix a meeting with him as soon as possible, and I hope that he can come. And there is this paper table or letter tabled, and this is a letter from the Hong Kong's media. Is it that we've all got a copy? The administration hasn't got a copy. I hope that the clerk can give the administration a copy. And it says that the definition of communications should be amended. When the legislation was passed, communications meant mainly postal items, but now we use WhatsApp, and this I think it's like a dinosaur to many, right? So people have very advanced communications equipment, and I believe many people now use WhatsApp, and they are saying that we need to update the definition of communications. The Deputy Secretary told us that many had been consulted, and so I wish to know whether this organization has also been consulted. Deputy Secretary, please. Yes, the member wants to know whether social media are covered by the definition of communication. In fact, a journalist put this question to the commissioner at a press briefing, and the commissioner said that he would not disclose the details of operations carried out by LEAs. But then, authorized interception operations must be carried out in accordance with the law and in full compliance with the law. In fact, the ordinance defines an act of interception. An act of interception means concerning the transmission of the information by postal services and telecommunications services and systems. So does it mean that the WhatsApp is also covered? So, Chairman, I can only say that LEAs need to fully comply with the legislation. Perhaps our legal advisor can give us some advice. So it seems that emails and WhatsApp are also covered. We are not interested in the content of the interception acts or operations. So I don't think the Deputy Secretary has really answered my question. So is it that these are also covered by the definition of communication? Because some have the misunderstanding that WhatsApp and emails are not covered. So is it that the Commissioner should, in his annual briefing, tell the public what is going on? Is it that a higher level of transparency will be preferable? I just want to say that, Chairman, I did not suggest that emails and WhatsApps are covered or not covered by the definition. I just clarified that we're talking about, in the legislation, postal services and also transmission by telecommunications. And that's what is meant by an act of interception in the ordinance. Legal advisor. Yes, Chairman. Concerning telecommunication services and systems, these are defined under Cap 106. And no particular medium or media are specified. So transmission through electromagnetic energy is covered. But of course, it's up to the panel judge to decide whether the interception or the act of interception should be authorized. And we do not have any court case concerning the definition. But then social media, or if the social media are transmitted by telecommunications systems, then they should be covered. Now, I believe the police do intercept the social media, but are such acts monitored by the commissioner? Now, the DSS reply was vague. Now, in fact, according to the legal advisor, the social media are covered, but then the commissioner didn't really give a clear reply in his press briefing. And I think in this exercise, we should give a clear definition for communication, and that such acts of interception are also supervised by the commissioner. Yes, can you give us a paper on what is meant by in the process of transmission by telecommunications services? Yes, the Deputy Secretary. Yes, Chairman, I think Ms. Lau's point is important. When LEAs make applications in accordance with the ordinance, they can carry out the acts of interception only when they obtain authorizations from the panel judge.
So the commissioner can examine the protected products that have been obtained in accordance with the law. That would include interception products as well as surveillance products. And there is also no restriction on what should be examined by the commissioner. In other words, after the enactment of the amendment bill, the commissioner will then be able to discharge his duty to monitor such operations. What Ms. Emily Lau was asking was meant by acts of or means of communication. That has not been clearly defined, because in the past we had no idea as to what these would include. For example, social networking. So anything that is in the course of transmission can be covered. So next one, please. In fact, what I meant was, well, you don't really need to intercept such a social networking or social networking information, because you're actually looking at information or materials which have been sent to a particular target. And for information available on social networks, you do not have to intercept it before you can obtain it. Well, Mr. Tony Chair, I support the appropriate amendments to the ordinance in order to enhance the effectiveness of the mechanism under the law. And of course, members are all concerned that while we try to protect public safety and security, and we have to balance it against the need to protect people's privacy rights. That's why I am concerned that when the commissioner examines the protected products, to what extent can the balance be struck? Because in the past, the commissioner when he examines such protected products, do we have a ratio of such inspection? Would he be checking each and every case coming to him? Well, in the past, he did not have that power yet, and now we have got this express power given to the commissioner to examine such products. So in the past, what's the arrangement in place for him to examine the cases? So I'd like to know if he would like to check each and every case put before him in order to ensure that there would not be abuse of power by intercepting such, or by conducting interception operations by the LEAs. Deputy Secretary, yes, thank you, Mr. Chair, for your question. In fact, the Commissioner also attaches a lot of importance to that. So when he conducts inspection in what form would he be accessing the materials? So let me answer the question on the ratio of such inspections. In the past, concerning the number of interception cases, there were about 1,200 cases per year on average. With regard to covert surveillance, there might be a few dozens. So my understanding is that the commissioner is, of course, there to monitor. So it doesn't mean that he would be inspecting each and every case, but then under the mechanism, as he has said in the report, well, technically there can be records to find out if the LEAs have committed any non-compliance acts. And of course, the commissioner and the panel judge would be submitting a report on a weekly basis as to what operations have been carried out, what crimes have been involved, and what kind of authorization has been obtained and for how long. So the commissioner would be able to have access to such details, and then if he finds certain cases skeptical, then he would ask the LEAs to submit reports, and he also conducts regular visits to the LEAs to check the relevant documents and the application documents, and also whether or not the affidavits are in order. And there is also a mechanism for the LEAs to report to the commissioner on all cases which might involve LPP materials, journalistic materials, non-compliance cases, and irregularities sometimes, whether there might have been a breakdown of the devices and so on. Well, nobody has committed any mistakes, but then if there are irregularities, the LEAs also have to report to the commissioner in the first instance. And then the commissioner has already got this mechanism in place to look at these special cases, requiring the LEAs to keep all the documentation to enable the commissioner to conduct inspection to find out if any LEA officers have committed any mistake. That's why every year in his annual report, the commissioner would also set out the details of his work during the past year. So the commissioner has been discharging his functions very cautiously and carefully, and he is asking for such powers which are very proportionate to his functions and duties. Yes, Mr. Chair. Well, I'm asking these questions, and from what I've heard from the Deputy Secretary, my understanding is that depending on the nature of the cases, the Commissioner might think that it's fit for him to check those cases. So what I'm concerned is that once the powers have been expressly provided for the Commissioner, then he would be using a lot of manpower to do it, because he might not be personally doing that, and he might authorize his colleagues to do the job. When it comes to authorization, in the past, he's not allowed to do that, right? Deputy Secretary, well, during the past few years, the Commissioner has not conducted any examination on the intercepted products. But then when he discharges his other duties of monitoring, he is also supported by his senior staff in the office. So they would accompany him in his visit to the LEAs and also in conducting the inspection of the documents and so on. So other civil service staff would be accompanying him when he discharged his duties. All right, now that you are asking for an express power for the Commissioner to inspect such materials, in the past he might have spotted such problems, and it's not just the Commissioner who had identified those problems. His staff will also do that. But then I'd like to know if it's the Commissioner personally making the decision to inspect or examine such materials, because if the number is too large, because well, during a certain period of time, you might have a lot of cases being underway, then the Commissioner would have access to more such materials. That's why we are all concerned that with more people having access to such products, then we are concerned about the mechanism itself, because the law is silent on who would be authorized, and of course it's for the Commissioner to decide, and he would be doing so reasonably, so that officers above a certain rank would be authorized to examine such protected products. So is my understanding correct? Because what we are concerned about is, as Mr. Christopher Jones said, would the power be too excessive, so that there needs to be some checks and balances. And also, given the materials that they might have access to would be very large in quantity, well, we have to ensure that the mechanism in place is proper. So the Commissioner would be coming up with internal guidelines. So I hope that the Deputy Secretary can do something about it. My time is up. I hope that she can reassure us that the mechanism is right, because all we want to do is to strike the right balance, right? Yes, Mrs. Ng. Well, thank you for the question. Well, other than the Commissioner and his team, who have been very cautious in exercising their powers, the Commissioner also shared members' concerns. That is that the materials should not be accessible by too many people. That's why he would be restricting the number of authorized officers to the minimal. And they would be senior officers in the office. And in the LEAs, only officers above the rank of inspectors would be allowed to conduct such operations. And they would also have to go through very intensive security checks or integrity checks. And as to how they assist the Commissioner to discharge his duties, they would also have to report to the Commissioner. All right, Mr. Ma Fong Kwok and then Sin Chung Kai. Thank you, Chairman. First, in principle, I would be prepared to support the proposed amendments. But then indeed, as some members have said, they have certain concerns and I share them. And I don't propose to repeat them here. But then in the administration's reply, we were told that in transferring the protected products, all right, at present they are not allowed to be transferred, so they would not be transferred to the Commissioner. So it's for the Commissioner to personally go to the LEA's premises to inspect those materials. But then in the future, when the Commissioner or his authorized officers find them to be problematic, do they have to retain such products or make copies in order for him to collate the information and draw some conclusions? So he will have to retain the products, because he simply cannot possibly work in the premises of the LEAs. He has his own office. So after all, it would involve the transfer of such products. So what's the mechanism in place? So is there any set of procedures regulating the transfer of such products? I can't see that in the administration's paper. And the second question is, the administration explained that the appointment of the Commissioner would have to meet certain requirements. But then what about the officers who are authorized by him? What are the ranks, and would they be subjected to integrity check before they can be authorized? So can the administration tell us more? Would there be a restriction on the number of such authorized officers? And do they have to work in the office of the Commissioner, or do they have to stay in the premises of the LEAs where such protected products are kept? And the LEAs also have to put in place arrangements to stop or discontinue such operations as soon as reasonably practicable. So what does that mean? What's meant by as soon as reasonably practicable? And are there any mechanisms in place to monitor the LEA's discontinuation of such operations? Is there a mechanism to monitor that? So you talk about doing so as soon as reasonably practicable, but then is there any mechanism in place to ensure that they would indeed do that? Well, I'll be answering the questions raised by Mr. Ma. As to whether or not the protected products would be transferred, as I said, according to my understanding, the former Commissioner and also the incumbent Commissioner said that when they examine the products, they would go to the premises of the LEAs to inspect or examine cases which they felt needed to be examined. In the process, the Commissioner would not copy the recordings or any such products by any means. In fact, the security measures are very stringent. In the previous report by the former commissioner, he said that when LEA officers, well, suppose they are just intercepting a communication, and then the officer listening in after listening for several seconds with regard to the discourse, all right, after listening to the first discourse, has he repeatedly listened to that, everything has to be recorded. Similarly, when the commissioner or his staff have access to such protected products, other than what I said earlier, according to my understanding, they did not intend to make copies of those products, and any such access would be electronically recorded as to which parts they have accessed, so you can always double check and audit such acts. So there would be detailed logs of such acts. With regard to the question on authorized officers, well, we would restrict that to a very small number of personnel. And my understanding is that in applying for resources, well, he has only applied for the creation of 3 additional posts to assist him to do this job. And these are relatively senior officials. They would be above the rank of inspectors. So they would provide assistance to the commissioner, and they would also have to pass intensive security check or integrity check. So this is for very senior ranking officials. And as I said, the number would be restricted, and they would only go to the premises of the LEAs to do such job.
Mr. Ma has referred to another technical amendment, and that is when the authorization is revoked, there is a time gap between the revocation of a prescribed authorization by the relevant authority and the actual discontinuance of the operation by the LEA. And this time gap is unavoidable. It's a technical problem. Now, when the LEA makes a report to the panel judge, and the panel judge may decide to allow the LEA to continue the operation, or may disallow the continuation of the operation. But then the LEA can't really discontinue the operation immediately, and there is this time gap of say 10 minutes or so. And now we propose to require LEAs to discontinue the operation as soon as reasonably practicable. And considering this time gap, there is a record of this of the duration of the time gap. So the materials will not, or the products will not be taken away. But what about the written records? Are they also protected products, or can the officers take away their written notes, or can they take away the written materials? Now, in fact, the commissioner at the moment does study these written records. And I want to say that, in fact, there are very rigorous security measures in place. So, when the protected products, at the moment, I mean, when the protected products are studied, the commissioner has to be present. But what's going to happen in the future? Now, I believe the commissioner will come up with very stringent and rigorous guidelines as to whether the commissioner will be present when the protected products are studied. I don't have the information, but at the moment his officers have to report back to him. But at the moment no officers are authorized, but at the moment the commissioner is assisted by his staff. There is a secretariat working under the commissioner. So the Secretary General and a few senior colleagues are now assisting the commissioner in his work. My understanding is that they do have access to highly sensitive materials, and they have to report their work to the commissioner and to the Secretary General. But under the existing legislation, only the commissioner studies or inspects or examines the protected products. There is authorization. Is there authorization? Should I ask? Chairman, now the ordinance or rather, we are now proposing to give express power to the commissioner to inspect the protected products. Now for the other powers now exercised by the commissioner, as you know, the commissioner can't do everything all by himself. He is supported by his office, the secretariat staff. I think whether he is present or not is not the most important thing. Now, maybe the commissioner may be inspecting certain protected products at one place, and his staff are inspecting other protected products at another place. I think what is important is that these staff members are properly or duly authorized, and they have been subject to integrity checks and vetting. So we are here particularly concerned about information subject to LPP or journalistic material, and so we think there's a need to provide for an express power, and that is the commissioner can inspect the products, and then only the authorized officers in his office can inspect the products. But then, yes, there may only be a few authorized officers, but then these authorized officers may have to be assisted and supported by other staff members. Chairman, protected products are highly sensitive materials, and of course the commissioner can inspect the products, and he can authorize a few of his staff members to inspect the products. But I don't think the few staff members can give further authorizations to inspect the products. So there shouldn't be another tier of authorization. But now this bill seeks to give the commissioner this express power, but I'm worried that the authorized staff members may be able to give authorization to their subordinates. We're talking about very sensitive and very important materials, and so this bill is about giving an express power to the commissioner and allowing the commissioner to authorize a few staff members to do the inspection. I'm worried that there may be further authorization. Legal advisor. Now, according to our legal principles, unless authorized persons or officers are allowed to make further authorizations. Otherwise, they cannot make further authorizations. The commissioner, in exercising his duties, has to personally do certain tasks if it is stated very clearly in the law that only the commissioner can perform such tasks. The executive is proposing this amendment to give an express power to the commissioner to inspect protected products. This is to avoid any doubt or any dispute. The reality is that the commissioner can't do everything all by himself, and so there should be this mechanism of authorization. According to the executive or the administration, the commissioner is bound by Section 17 of the Official Secrets Ordinance. So the commissioner can't disclose the content of protected products. Now, of course, there is Section 17 of the Official Secrets Ordinance. But then the Official Secrets Ordinance, Section 17 is about materials possessed by certain people. And so having just Section 17 alone may not be enough for this purpose. So is it that only the commissioner and those authorized by him can inspect the protected products? Others cannot. I mean, others in his office cannot. Chairman, only the commissioner can give the authorization. That's clear. And as the legal advisor has pointed out, the authorized staff cannot authorize their subordinates to inspect protected products. Ms. Claudia Mo. So in other words, the tenant can't sublet the premises to other people. Of course, that's reassuring. But then, Chairman, I want to say that concerning journalistic materials, we're not only talking about written materials or the content of phone calls. What about WhatsApp? Journalistic material. Now, Chairman. Now, you may look at my WhatsApp, but then I may have some WhatsApp conversation with journalists, and that's journalistic material. So my first question is whether you are being unfair to the journalists concerned. And sorry, Chairman, I was a bit late. What about Messenger or on Facebook, the inbox? I don't know how these are translated into Chinese. So what about these? Are these materials also covered by the ordinance, and can they be presented in court? And then, Chairman, I think we should have a public hearing first. Ask the deputations to come. And then if some people think that their freedom of thought and their freedom of communication are affected, then they should be given a chance to state their concerns to us. Now, Ms. Mo, in fact, the public hearing will be on the 2nd of May. Then concerning Facebook and the social media, in fact, there was some discussion before you arrived. Deputy Secretary. Thank you, Chairman. Concerning the social media, now on Facebook, there are some open materials. And the police do collect information about crime through various open channels. But then if there is to be an act of interception, then that act has to be in compliance with the definition, and that is the interception of the communication, or the communication rather, has to be transmitted by the telecommunication system. Now, we cannot comment on or disclose the operational details of LEAs or the modus operandi of LEAs. But then when an LEA makes an application to a panel judge, the LEA must comply fully with the ordinance, and the crime concerned must be a very serious one. For example, an offense which attracts an imprisonment term of at least 7 years. And the panel judge looks at necessity and proportionality. For example, whether the LEA can have other ways to obtain the materials, and whether interception of communication is the only option. And then journalistic material, in fact, the administration as well as the former commissioner and the incumbent commissioner are concerned about journalistic material because there was a problematic case. Yes, true.
Yes, indeed, there was a case. That's why both in the code of practice and also under the law, there are safeguards. So if the LEAs, if they want any authorization, then they will have to prepare a written declaration or affidavit which will have to be passed on to the judge or the authorizing officer, so that he would have to make an assessment on the chance of accessing journalistic materials or LPP materials. So such an assessment will have to be made in the written affidavit. All right, even if there is no intention of obtaining this in the first place, but then in the course of the investigation, if there is a rising chance of the LEA having access to such materials, then he would have to, the LEA would have to report to the panel judge immediately as to what they have intercepted, and then the panel judge would decide whether or not the operation can continue, or if the panel judge is of the view that by continuing the operation that's no longer in compliance with the law, then the panel judge can discontinue or revoke the authorization. And the former commissioner was also concerned, and he also recommended that we should revise the COP in order to step up the protection for journalistic materials. But then if it's the second type of operation, which is less intrusive, the former commissioner also said that if it involved journalistic materials, then it has to be approved by the panel judge. So these are the measures that are in place. And just now, another question asked was about any restriction or limit on the power. So they can only intercept communications within Hong Kong's territory, so that they can apply for an authorization for them to intercept such communications. So that's the requirement. Thank you. Chairman, allow me to ask one more question. Well, according to my understanding, when it comes to interception or surveillance operations, of course, you're trying to counter terrorism because, well, worldwide, we are all concerned about this, and also for drug trafficking or extreme violence. For example, you said that the imprisonment term has to be no less than 7 years. So these are relatively serious crimes. So what about political acts? Would that also be covered? Mrs. Ng.
Chairman, we have also put this to the former commissioner as well as the incumbent commissioner. They know it the best because they're responsible for that, and they've also publicly said that they have not seen the LEAs conducting any political surveillance because the commissioner has been having a very difficult time, and the LEA, when it wants to make an application to the commissioner or the panel judge, the LEA will have to furnish a lot of materials. They will have to fully justify the operation as to what crimes are involved, why they have to do it, why no alternative ways can provide the same kind of information. And then the panel judge would judge that it is fully justified. So the threshold is extremely high. But then please note what our legal advisor said, because the authorization is by the commissioner. And then what about the safeguards for the non-government sector? Apparently that's not done enough. So please take a second look. All right. Mr. Kwok Wai Keung, all right, the amendment would enhance the power of the commissioner so he can conduct spot check or random check of the cases. But as we have been told, applications can only be made when it involves investigation of relatively serious crimes. So it's been in place for 9 years. Still, there is room for improvement, and on this occasion, it's an improvement bill. But then what we are concerned about, as some have said, all right, internet communications would not be covered. So you're just talking about communications which will be intercepted. But then, other than WeChat or WhatsApp, which are basically text messages, but then with advancement in technology, there is also the capability for such software to provide internet calls. So if there is such online calls, would it be intercepted as well? So are there any inadequacies in the bill, or how much time would be needed for you to conduct a review? When would that be covered? Because if I want to circumvent the rule, then I would just use the software to engage in online chats. Well, as the legal advisor said, for the means of communications, that has not been very clearly defined in the bill. Thank you, Mr. Kwok, for your question. Well, setting aside the ICSO, with the advancement in technology, there is a lot of information being communicated online. That would also pose a lot of challenges to the LEAs. So they would not just be finding the clues of the case at the scene. So, for example, you might know a few people, and then they would just investigate those few people. But then, when it comes to online communications, you might have several hundred friends. So it would be very difficult for them to investigate. So for the operation details and also for the investigation, we are not allowed to disclose the details. But then for the Interception Acts allowed for under the bill, the communications would be done via electronic means. So any communications sent via electronic means can be subject to the interception of communications. That's what's defined in the bill. And such communications will have to take place within Hong Kong. As to individual medium, the difficulties encountered by the LEAs in combating crimes, of course, are very multifaceted. But then the LEAs would try their best wherever the law permits to combat such crimes. Mr. Kwok, from what I've heard, as the server of such software might be outside Hong Kong, and therefore there is no way that you can check on them. So in the future, if they really try to circumvent the rules by engaging in such online checks by using the software, so is it that you will simply not be able to deal with that? So if such checks take place outside of Hong Kong, then is it that you cannot do anything about it? Well, there are also many technology crimes.
And previously, as our Bureau has explained, if it involves activities outside of the territory, then there might be difficulties cracking down on such activities. So in this regard, the police or other LEAs will have to resort to other channels through international cooperation, so that where the law permits, they will take action against such crimes. All right. Anyone else in the first round? Mr. Peter Charles Mock. Thank you, Chairman. I was having a meeting next door. It's okay. Chairman, I'll speak more softly because while I was attending a meeting next door, I was listening into this meeting. I heard the questions raised by some members. Well, I'd like to ask this again, even though it might have been asked by other members. I'd like to ask them from my perspective. Well, some of them might not be directly related to this bill, but then as we have seen in the paper and outside, there are other colleagues who have had a lot of comments about this ICSO. In the past, I have seen, and I've also put this to the administration as to what are the acts of communications which would be subject to this. So very strangely, apparently you can only regulate the administration, not the other people. So this is not included in this amendment. But then what it says here, in particular, when I heard the meeting, I also heard Ms. Mo asking this. I don't know if other members have also asked this. With regard to internet communications, I think there are some unclarities here. So the reason why I'd like to say this, that's because I'd like to share with you what I think is necessary. All right, when it comes to interception of communications, I think the interpretation is outdated. So you might be thinking about going to the cinema in the 70s, so you would be intercepting the phone chats. But then when it comes to the internet, they have the store and forward. So you may also have instant communications, but then under different systems, it would also involve the transmission of communications, because the design of the internet system is for communications to be transmitted by storing and forwarding. So in many cases, the LEAs, well, just now, when I heard you, you said that you would have to do it through some telecommunication systems. So I think if it's defined very broadly, many of such communications are transmitted through telecommunication systems. But then precisely, what we have seen is that when the LEAs try to get hold of information online, when they make inquiries with the ISPs, they don't even use a search warrant. So for 3 consecutive years, I've been asking which departments of the government would go to the ISPs for removal of information or having access to certain information. I've been asking this year after year. Well, when I ask if they've got or apply for search warrants, either they would not answer my question or they would try to evade it. So on the one hand, you are doing this, but then on the other hand, in fact, the effect is the same. The only difference is that in the future, well, if you want to circumvent any monitoring that Ms. Mo, then we should be making calls, and then only in very serious cases they would try to intercept your calls. But then for online chats, you can do it very casually. So this law or other pieces of legislation would not be able to regulate the LEAs when they conduct such operations. Well, the proposed amendments might not have covered what I just said, but then out there, the public are very concerned about this. Because this ordinance is too narrowly defined, and it would only regulate the government. But then the most prevalent cases, which might have involved excessive interception of communication through the internet, that would not be subject to the regulation. And I don't know whether or not you have winked, because 2 years ago I also put this to the Commissioner and I asked him if the internet would be covered, and he was not able to give a reply. So that's my first concern. And the second concern, all right, for the Hong Kong in media, they have talked about the storage of the interception, devices, because you can always store some materials, and how would that be dealt with? Precisely because we all know that there is importance to this. Because as I said, the internet itself is operated on store and forward basis. So what we are most concerned about is that after the materials are intercepted, they would be stored, and there might be cases of mishandling or loss of such materials. So that's one problem. And precisely, we have to know that even for instant communications, when such communications are being stored, that should also be subject to very stringent regulation. That would also goes back to the internet environment where information is stored and forwarded. And still, there is no way for the administration or the LEAs to do it. So they don't even have to get hold of a search warrant, and then they can access the information. But then under the law, the whole process is very complicated. So there is inconsistency here. And once there is inconsistency, that would give rise to a lot of problems. So can the administration answer this question? Thank you. All right, let me try to respond to the different parts of the question. Your question is that the LEAs can use portable media in intercepting the communication. That's right. And the Commissioner attaches a lot of importance to the retention and the devices being used. In particular, upon the taking office by the incumbent Commissioner, he can say that, well, when it comes to interception of communications, there is a second mechanism in place. So the incumbent Commissioner said that we had to step up the monitoring of such portable devices when they store certain materials. We have to make sure that no officer would be allowed to alter the information without authorization.
So the Commissioner has been following up with the LEAs, and in fact this concern was also raised by the Commissioner during his press briefing. And LEAs can approach ISPs for information. That's true. Of course, Mr. Charles Mock has his concerns, but then that must be subject to the consent of the ISP to provide crime-related subscriber information. And the information obtained from the ISP will not be the content of communication. The information is subscribers' information. Concerning the content of communication, that's a protected product. And if the LEA wants to get the content of communication, then it must get authorization. The ordinance prohibits all public officers from carrying out unauthorized interception of communication. Then a definition of internet communication. I want to say that the definition is clear. It's about communication transmitted by the telecommunication system. LEAs need to follow this definition. And then non-public officers. This ordinance binds public officers. Public officers include people like us. Although we are not in the LEAs, we are also bound by the ordinance, and LEAs need to apply for authorization. In fact, in the LLC, there is a series of reports on whether there should be a regulation of interception of communication by non-public officers. In other words, members of the public. Of course, there are privacy considerations and other considerations, and the relevant bureau is following up. But that will not be addressed in the context of this bill. Yes, Chairman. I will not follow up on the points I made that are not directly related to this bill. Now, concerning obtaining content of communication, the DS said that this is subject to this ordinance. I want to say that in fact, many think that LEAs do obtain content of communication rather lightly and easily. So we think there should be a code of practice. I want to say that one department was responsive and the other didn't really do anything concerning drawing up a code of practice. Yes, the LEAs may just want to obtain the subscribers' information, but then still, this is very sensitive information. And maybe the administration can give us a written reply next time. I want to have a written reply as to whether the content of communication on the internet also falls under this ordinance. And perhaps we, because the sector doesn't really understand. Say, if a police officer or a law enforcement agency calls and asks for certain information, then the ISP just provides the information. So I think it's important that there should be clear information for the sector. Right? We don't have other members who are in the first round. So then that was why I allowed Mr. Mok to continue. So can the Bureau give us a written reply? Yes, we can give a written reply on the policy aspects. If the interception is or takes place in the process of transmission by the telecommunications system, then definitely such an act comes under the ordinance. All right, so perhaps we'll await the written reply from the administration. All right, members, do you have further concerns? Ms. Emily Lau. Yes, Chairman. Also, or still on the suggestion made by Hong Kong in media, page 2, paragraph 3, they propose that there should be a provision on the protection of journalistic material. So in other words, they think the journalistic materials like information subject to LPP should be protected. So can you tell us what the present situation is? And do you really support this proposal? Yes, Chairman. In reply to Ms. Mo's question, I outlined the existing measures which were stringent. Now, the bill seeks to give the Commissioner an express power to inspect protected products. And we are also talking about information subject to LPP or journalistic material. The former Commissioner was concerned that there might be discrepancy between the content in the AgendaI and what was listened to. And so the former Commissioner suggested the inspection mechanism. So the Commissioner will be able to inspect the protected products, and that will mean more protection with regard to LPP materials and journalistic materials. Chairman. So does it mean that there will be equal protection for information subject to LPP and journalistic material? Chairman. Now in the bill, the Commissioner can inspect any protected product. And that of course includes cases involving journalistic material. Now why is it that LPP was or is specifically mentioned in the ordinance? This is because for LPP, of course, there is absolute protection. But I want to say that in this bill, protected products definitely include journalistic material. So with this power, the Commissioner can inspect all protected products, including those containing journalistic material. So that's section 13. So protected products definitely include journalistic material. Journalistic material is also covered, right? Because journalistic material is not specifically mentioned. But you are telling us that journalistic material can be covered by any protected product. Yes, that's correct. Perhaps Mr. Khan from the DOJ can clarify. The question is whether we should in section 53(1)(a) specify LPP as well as journalistic material. Now, why is it that we are proposing to specify LPP here? This is because protection of information subject to LPP is a very important right, and that's in Article 35 of the Basic Law. Because all Hong Kong people have the right to have access to confidential legal advice. This is a very important right. So this very important right is fully protected. And so information subject to LPP is different from journalistic material because, generally speaking, journalistic material is for publication purpose. And so the consideration concerning the extent of protection for journalistic material is different. And that's why in 53(1)(a), we are proposing to only specify LPP. Yes, we understand that LPP is absolute. But but I believe the government also thinks that journalistic material is very important. Journalistic material is not specified. It's covered by any protected product. Yes, maybe journalistic material is not absolute in its importance, but if you do agree that journalistic material is very important, then why can't you also specify journalistic material? Yes, we understand Ms. Lau's suggestion. We'll bring that back for consideration. All right, so I understand that any protected products do include journalistic material, although journalistic material is not specified. All right, anyway, any other questions? Then let me raise 2 points. So the public hearing will be on the 2nd of May. And some members, including Mr. Ho, suggested that we should invite the former commissioner to a meeting. Now, my suggestion is that we'll meet the deputations on the 2nd of May, and perhaps we can, before the public hearing, set aside 30 minutes to meet the former commissioner and maybe the incumbent commissioner. But then, so if they agree to come, then we'll start at 8:30. If they do not want to come, then we'll start the public hearing at 9. If the former commissioner agrees to come, then 30 minutes will not be enough. He put forward a total of 5 reports, and some administrative revisions were made in accordance with his suggestions. And the former commissioner said that the power to inspect all protected products was important. So if the former commissioner really agrees to come, and I think we need 2 hours, we need a full 2-hour meeting with him, because I believe many members will have many questions for him. But of course, first of all, we have to ascertain whether he is willing to come.
Well, let's write to him first. So if we want to schedule a meeting after the 2nd of May to invite the commissioner to come, then if you want to give him more time, maybe an hour or so, it's okay. So if he's willing to come, then we'll schedule a meeting for that. Can we agree on that? Yes, Ms. Emily Lau. Chairman, I agree that we should give enough time to the former commissioner. So I don't know what Justice Wu might think. He might not be willing to attend our meetings. So basically, for judges, they are not willing to come and attend meetings of this council. So while he was the commissioner, he asked us to go along, and he has a venue to meet with the reporters and so on. So you will have to find out from him if he is not willing to come, because being a judge, he doesn't really want to take questions from us. So I think wherever the venue is okay, so long as we can have a chance to talk to him, because what we would like to get is the advice from him. So whether he comes or not is okay, so long as he doesn't mind exchanging views with us. But then if he doesn't want to come to this council building to attend our meetings, then would it be okay for us to arrange for an occasion when we can talk to him? So unless he doesn't really want to meet with us at all, then of course nothing can be done about it. But then if it's just that he wants to talk, but then he doesn't want to come, then we can try to make it possible. But then we also have to be accountable to the public, because all our meetings are open. So I do not mind using other occasions to talk to him and find out what he thinks. But then if it's not a formal meeting, then would we be interested? I don't really want to say that it's going to be a private meeting, but then if there is a chance for us to find out more from him, I think it's for us to decide. It might not be done via the Bills Committee, because the Bills Committee's meetings have to be public. So I'll consult with members and listen to your views first. But then I personally think that if we have to go to his office to talk to him, that might not be appropriate. Yes, Mr. Yu. All right. After all, we are concerned about this, and if we go to a particular premises to talk in private, I think the best thing is for us to resort to the formal avenues, or else if there is any skepticism, because this bill is pretty sensitive, that might not be very good. And as the former commissioner, it's for him to decide if he wants to come, and if he refuses to come, then he will have to shoulder the consequence. So we should not be speculating as to whether or not he might not wish to come, and therefore we might have to meet him at other premises, because I don't want to set a very bad precedent for this. Well, the legal advisor just suggested that we can invite them, and if he can make it, then if he can't make it, he can also submit written information to us. And if members are interested, if you want to get more in depth, then we could also meet him in private. So it can be in the form of an informal meeting. Yes, Miss Emily Lau. Well, we are talking about the former commissioner. We are not talking to him in private. Well, he has been very public, because on other occasions the reporters were there. It's just that he doesn't want to come to this building. All right. He made it clear that he didn't want to come to this building. So it's not a private meeting, because it was conducted in the public glare of the reporters. Okay, so we can invite them. We can invite him to come on a date after the 2nd of May. And another point that I'd like to consult you is, well, members have raised some of their concerns just now. So, do we want to scrutinize the issues in accordance with the format of the government's paper? For example, on protected products, partial revocation of prescribed authorization, and so on. So if we follow those headings, I think that would be more effective. So for the specific scope of discussion, we would be setting that out in the paper, so that we would know the sequence of the subjects to be discussed. So when are we going to have another meeting? Well, the 2nd of May will be our public hearing, and the secretary has also checked the slot. First, 11th of May, Monday, 8:30. So 11th of May, Monday, 8:30. 29th of June, Monday, 2:30. What day in June? 29th of June, Monday, 2:30. The reason why we have to arrange for that, as we know, for Thursdays and Fridays, there is a slim chance that we can schedule a meeting. What about June the 29th? What time? 2:30. So we can only have meetings on Mondays and Tuesdays, and it's highly competitive to schedule a meeting on Mondays and Tuesdays. That's why these are the only slots that we managed to get. All right, AOB, none. So I'd invite members to jot down May the 2nd, Saturday, 9 to 12. We're going to have a public hearing. We'll be writing to the interested parties to listen to their views. So meeting is now adjourned.